Question 1. The review process indicates that a firm has received a substantial allocation of a highly anticipated initial public offering, IPO, in California. The firm's compliance department is concerned about the allocation process and is seeking to ensure adherence to FINRA regulations. Which of the following represents the most appropriate method for allocating these new issue shares to clients? Option A. Allocate shares to bona fide customers based on the firm's written new issue allocation policy, which prioritizes clients based on investment objectives, account size, and prior participation, while strictly prohibiting allocations to restricted persons or for the purpose of immediate resale. Option B. Allocate a significant portion of the new issue to the firm's proprietary trading desk and to a select group of large institutional clients with whom the firm has strong relationships, without a detailed, predefined allocation policy for this specific offering. Option C. Allocate shares to newly opened accounts that have expressed interest in the IPO, with the understanding that these accounts may sell their shares shortly after the market opens to realize a quick profit. Option D. Allocate a substantial number of shares to the personal brokerage accounts of senior management and their immediate family members, who are considered long-term investors but have not previously participated in new issues. Correct answer is A. Allocate shares to bona fide customers based on the firm's written new issue allocation policy, which prioritizes clients based on investment objectives, account size, and prior participation, while strictly prohibiting allocations to restricted persons or for the purpose of immediate resale. Explanation. The review process indicates a potential challenge in ensuring fair and equitable distribution of a highly sought-after new issue, specifically within the context of FINRA regulations governing the securities industry in the United States. The professional challenge lies in balancing the firm's business objectives, client relationships, and the stringent regulatory requirements designed to prevent manipulation and ensure fair access to investment opportunities. Mismanagement of new issue allocations can lead to accusations of favoritism, insider trading, and market manipulation, all of which carry severe penalties. The best approach involves a systematic and documented process that prioritizes bona fide customer orders and adheres to the firm's written new issue allocation policy. This policy should clearly define the criteria for allocation, such as client investment objectives, account size, and prior participation in new issues, while strictly prohibiting allocations to restricted persons or for the purpose of flipping. This method ensures transparency, fairness, and compliance with FINRA Rule 5131, which prohibits the allocation of new issues to accounts of persons associated with other FINRA members unless specific conditions are met, and generally aims to prevent manipulative practices. An incorrect approach would be to allocate a significant portion of the new issue to the firm's proprietary trading accounts, or to favored institutional clients without a clear, pre-established, and consistently applied policy. This raises concerns about potential market manipulation and unfair advantage, violating the spirit and letter of FINRA Rule 5131, which aims to prevent the artificial inflation of demand or the manipulation of the secondary market. Another incorrect approach is to allocate shares to the personal accounts of firm employees or their immediate family members, especially if these individuals are not bona fide customers with a demonstrated investment history and objective that aligns with the new issue. This practice is a direct violation of FINRA Rule 5131, restrictions on allocations to restricted persons, and can be perceived as self-dealing or insider favoritism. Finally, an incorrect approach would be to allocate shares to new accounts opened solely for the purpose of receiving the new issue, particularly if there is an understanding or expectation of immediate resale. This strategy circumvents the intent of fair distribution and can be indicative of a flipping scheme, which is explicitly prohibited by FINRA Rule 5131 as it distorts the market for new issues. Professionals should approach new issue allocations by first understanding and strictly adhering to the firm's written supervisory procedures and FINRA regulations. This includes maintaining detailed records of all allocations, ensuring that all allocations are made to bona fide customers based on objective criteria, and regularly reviewing the allocation process for compliance and fairness. A proactive approach to compliance, coupled with robust internal controls, is essential to navigate the complexities of new issue distributions. Question 2. Performance analysis shows that a new registered representative in Ontario, Canada, is about to complete their initial registration process. The firm's compliance department is reviewing the onboarding procedures to ensure adherence to all regulatory requirements, specifically concerning the acknowledgement of arbitration clauses. Which of the following actions best ensures compliance with the regulatory framework governing the disclosure of arbitration clauses to associated persons prior to signing or acknowledging Form U-4? Option A. The firm provides a general overview of arbitration to all new hires during a group orientation session, without specifically linking it to the Form U-4 acknowledgement process for each individual. Option B. The firm includes the arbitration disclosure as part of the standard Form U-4 package, assuming the registered representative will read and understand it during their review of the entire document. Option C. The firm's hiring manager briefly mentions that Form U-4 contains arbitration clauses and that signing it means agreeing to arbitration, without further elaboration. Option D. The compliance officer provides the registered representative with a copy of the arbitration disclosure language from Form U-4, explains its key provisions including the waiver of jury trial rights and the binding nature of arbitration, and confirms the representative's understanding before they sign the form. Correct answer is D. The compliance officer provides the registered representative with a copy of the arbitration disclosure language from Form U-4, explains its key provisions including the waiver of jury trial rights and the binding nature of arbitration, and confirms the representative's understanding before they sign the form. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a critical disclosure requirement under FINRA rules that directly impacts an associated person's ability to engage in securities activities. A failure to properly execute this disclosure can lead to significant regulatory sanctions for both the individual and the firm, including fines, suspensions, and reputational damage. The challenge lies in ensuring that the associated person fully understands the implications of signing or acknowledging Form U-4, particularly concerning arbitration. Correct approach analysis. The best professional practice is to ensure the associated person fully understands the arbitration disclosure on Form U-4 before they sign or acknowledge it. This involves not just presenting the form, but actively explaining the nature of arbitration, its binding nature, the waiver of jury trial rights, and the implications for dispute resolution. This approach is correct because FINRA Rule 2263 mandates that firms provide a written pre-dispute arbitration clause disclosure to any applicant for registration. The rule emphasizes that the applicant must be given a copy of the clause and understand its contents. Merely having the applicant sign the form without ensuring comprehension falls short of the spirit and intent of the rule, which aims to protect individuals by ensuring informed consent. Incorrect approaches analysis. One incorrect approach is to simply have the associated person sign Form U-4 without any discussion of the arbitration disclosure. This is a regulatory failure because it bypasses the requirement for the applicant to understand the implications of agreeing to arbitrate disputes. The rule is designed to ensure informed consent, not just a perfunctory signature. Another incorrect approach is to assume the associated person has read and understood the arbitration disclosure simply because it is part of Form U-4. This is a failure of due diligence. Firms have a responsibility to ensure their associated persons comprehend significant disclosures, especially those that waive fundamental legal rights. A further incorrect approach is to provide a generic, brief explanation of arbitration without tailoring it to the individual's potential questions or concerns. While some explanation is better than none, a truly compliant approach requires ensuring comprehension, which may necessitate a more detailed or personalized discussion. This approach risks superficial understanding rather than genuine awareness. Professional reasoning. Professionals should approach this situation by recognizing that compliance with FINRA Rule 2263 is not merely a procedural step, but a substantive requirement for informed consent. The decision-making process should prioritize clear communication and verification of understanding. This involves scheduling dedicated time to review the arbitration disclosure, using plain language to explain complex legal concepts, encouraging questions, and confirming that the associated person grasps the significance of agreeing to arbitrate. When in doubt about the applicant's comprehension, further clarification or consultation with compliance personnel is warranted. Question 3. The risk matrix shows a moderate likelihood of regulatory noncompliance related to the onboarding of new registered representatives in the state of California. As a branch office supervisor, what is the most appropriate initial action to take when a newly hired candidate for a registered representative position indicates they have passed the Series 7 and Series 63 examinations and has no prior disciplinary history? Option A. Instruct the hiring manager to conduct a thorough background check, focusing on criminal records, and consider this sufficient verification of the candidate's qualifications for registration. Option B. Accept the candidate's verbal confirmation of passing the examinations and the absence of disciplinary issues, and proceed with the onboarding process based on this information. Option C. Proactively access the candidate's FINRA CRD record to independently verify their examination pass dates, license status, and review any disclosed disciplinary history before proceeding with registration or allowing any registered activities. Option D. Immediately initiate the FINRA Form U-4 filing process and allow the candidate to begin supervised training activities while awaiting official confirmation of their licenses. The correct answer is C. Proactively access the candidate's FINRA CRD record to independently verify their examination pass dates, license status, and review any disclosed disciplinary history before proceeding with registration or allowing any registered activities. Explanation: the risk matrix shows a moderate likelihood of regulatory noncompliance related to the onboarding of new registered representatives in the state of California. This scenario is professionally challenging because it requires a supervisor to balance the need for efficient hiring with the absolute imperative of ensuring all new hires meet stringent regulatory qualification requirements before engaging in securities activities. Failure to do so can result in significant penalties for the firm and the supervisor, as well as harm to investors. The best approach involves proactively verifying the qualifications of newly hired associated persons by meticulously reviewing their FINRA CRD records, confirming the successful completion of all required licensing examinations, such as the Series 7 and Series 63, and ensuring that any prior disciplinary history has been thoroughly investigated and addressed in accordance with FINRA and California Securities Division regulations. This proactive verification process directly addresses the regulatory requirement to ensure that only qualified individuals are registered and permitted to conduct business. It aligns with the principles of investor protection and regulatory compliance mandated by FINRA Rule 1210 and California Corporations Code Section 25,230. An incorrect approach would be to assume that a candidate's self-reported qualifications or a recruiter's initial screening are sufficient without independent verification. This fails to meet the supervisory responsibility to ensure compliance with registration requirements. Relying solely on the candidate's assertion of having passed exams without cross-referencing with official records creates a significant compliance gap and exposes the firm to risk. Another incorrect approach is to allow a new hire to begin performing registered duties while their licensing status is still pending or unconfirmed. This directly violates the principle that individuals must be properly registered before engaging in securities transactions, as stipulated by FINRA Rule 1210A and California Corporations Code Section 25,210. Finally, overlooking or downplaying any disclosed disciplinary history on a candidate's record, assuming it is minor or irrelevant, is a critical failure. Supervisors have a duty to investigate all disclosures and assess their impact on an individual's fitness and eligibility for registration, as required by FINRA Rule 3110 and California's suitability requirements. Professionals should adopt a systematic and documented process for verifying the qualifications of all new hires. This process should include clear checklists, designated responsibilities, and a robust system for tracking the status of registrations and examinations. When in doubt about a candidate's qualifications or disciplinary history, supervisors should err on the side of caution and seek clarification from regulatory bodies or legal counsel before allowing the individual to commence registered activities. Question: the risk matrix shows a moderate likelihood of regulatory noncompliance related to the onboarding of new registered representatives in the state of California. As a branch office supervisor, what is the most appropriate initial action to take when a newly hired candidate for a registered representative position indicates they have passed the Series 7 and Series 63 examinations, and has no prior disciplinary history. Options: A. Immediately initiate the FINRA Form U4 filing process and allow the candidate to begin supervised training activities while awaiting official confirmation of their licenses. B. Proactively access the candidate's FINRA CRD record to independently verify their examination pass dates, license status, and review any disclosed disciplinary history before proceeding with registration or allowing any registered activities. C. Accept the candidate's verbal confirmation of passing the examinations and the absence of disciplinary issues, and proceed with the onboarding process based on this information. D. Instruct the hiring manager to conduct a thorough background check, focusing on criminal records, and consider this sufficient verification of the candidate's qualifications for registration. Question 4. Investigation of a newly hired administrative assistant at a registered broker-dealer firm in California reveals that while their primary duties involve scheduling meetings, managing correspondence, and maintaining office supplies, they occasionally assist registered representatives by retrieving client account statements from the firm's secure system and preparing them for review. Given these circumstances, what is the most appropriate course of action for the firm's general security sales supervisor to ensure compliance with FINRA registration requirements? Option A. Conduct a detailed review of the administrative assistant-specific tasks, comparing them against FINRA rules and guidance regarding exemptions for associated persons, to determine if their duties are purely clerical or ministerial and do not involve activities requiring registration. Option B. Assume the administrative assistant is exempt from registration due to their non-sales-oriented job title and the fact that their primary responsibilities are administrative. Option C. Allow the administrative assistant to continue performing these tasks, reasoning that their prior experience as a customer service representative at a bank means they are familiar with financial documents and therefore exempt. Option D. Interpret the occasional retrieval and preparation of client account statements as incidental to administrative support, and therefore not requiring registration, given the volume is low. The correct answer is A. Conduct a detailed review of the administrative assistant's specific tasks, comparing them against FINRA rules and guidance regarding exemptions for associated persons, to determine if their duties are purely clerical or ministerial, and do not involve activities requiring registration. Explanation: this scenario presents a professional challenge because it requires a supervisor to accurately identify when an individual performing certain duties within a registered firm might be exempt from FINRA registration requirements under the Series 9 and 10 General Securities Sales Supervisor exams purview, specifically concerning associated persons. Misinterpreting these exemptions can lead to regulatory violation, including operating with unregistered personnel, which carries significant penalties for both the individual and the firm. Careful judgment is required to distinguish between roles that necessitate registration and those that may fall under an exemption, particularly when the duties are not clearly defined or are evolving. The correct approach involves a thorough review of the individual's specific duties and responsibilities in relation to FINRA Rule 1031 and related guidance on associated persons exempt from registration. This approach prioritizes understanding the nuances of the exemption, which typically applies to individuals whose functions are purely clerical or ministerial, or who do not engage in activities that require security sales or supervision. By meticulously analyzing the tasks performed and comparing them against the established criteria for exemption, a supervisor can make an informed decision that aligns with regulatory compliance. This is correct because it directly addresses the regulatory framework governing registration exemptions and ensures that only those individuals whose roles are demonstrably outside the scope of registration requirements are permitted to perform them without being registered. An incorrect approach would be to assume an exemption based solely on the individual's job title or a general understanding of their department's function, without a detailed examination of their actual day-to-day activities. This is professionally unacceptable because it bypasses the critical step of verifying that the specific duties performed meet the strict criteria for exemption. Relying on assumptions, rather than a diligent review of responsibilities, can lead to the employment of unregistered individuals in roles that legally require registration, thereby violating FINRA rules. Another incorrect approach is to grant an exemption based on the individual's prior experience in the securities industry, even if their current role does not align with the exemption criteria. This is professionally unacceptable, as prior experience does not automatically confer an exemption for current duties. Registration requirements are tied to the specific functions performed within a registered firm, not past employment. A further incorrect approach is to interpret the exemption broadly to include individuals who may have incidental contact with securities transactions, even if their primary role is not sales or supervision. This is professionally unacceptable because FINRA rules are specific about what constitutes clerical or ministerial functions. Broadly interpreting the exemption risks allowing individuals to engage in activities that, while perhaps not their main focus, still necessitate registration to protect investors and maintain market integrity. Professionals should adopt a decision-making framework that begins with a clear understanding of the individual's role and responsibilities. This should be followed by a detailed comparison of these duties against the specific FINRA rules and guidance pertaining to exemptions for associated persons. When in doubt, consulting with the firm's compliance department or FINRA directly is the most prudent course of action to ensure accurate interpretation and adherence to regulations. Question 5. Comparative studies suggest that when a supervisor in Ontario, Canada, receives a credible client complaint alleging an associated person engaged in unsuitable trading practices, what is the most appropriate initial course of action to ensure compliance with provincial securities regulations and ethical standards? Option A. Take no immediate action, assuming the complaint may be a misunderstanding, and wait to see if the client escalates the issue further before engaging the associated person. Option B. Advise the client that the firm takes all complaints seriously, but that the associated person is a top performer, and the firm will handle it internally without further client involvement. Option C. Issue a formal warning to the associated person based solely on the client's complaint, pending a full investigation, and consider immediate suspension of their trading authority. Option D. Immediately initiate a formal internal investigation, document all findings, and consult with the firm's compliance department to determine the appropriate corrective actions, while ensuring the associated person is informed and given an opportunity to respond. The correct answer is D. Immediately initiate a formal internal investigation, document all findings, and consult with the firm's compliance department to determine the appropriate corrective actions, while ensuring the associated person is informed and given an opportunity to respond. Explanation. This scenario presents a common challenge for supervisors, identifying and addressing potential misconduct by an associated person without overstepping boundaries or failing in supervisory duties. The core difficulty lies in balancing the need for prompt corrective action with the requirement for thorough investigation and fair treatment of the individual. A supervisor must act decisively to protect clients and the firm while adhering to FINRA rules and ethical standards. The best approach involves a structured, documented, and compliant response. This includes immediately reviewing the complaint, gathering relevant information from the associated person and any other sources, and consulting with the firm's compliance department. This systematic process ensures that all necessary steps are taken to understand the situation, determine if a rule violation has occurred, and implement appropriate disciplinary or remedial actions, all while maintaining a clear audit trail. This aligns with FINRA Rule 3010, which mandates effective supervision and compliance procedures, and the general ethical obligation to act with integrity and diligence. Failing to take immediate, documented steps to investigate the complaint is a significant regulatory failure. Ignoring or downplaying a client complaint or delaying a proper review can lead to further client harm and expose the firm to regulatory sanctions. This demonstrates a lack of diligence and a failure to uphold supervisory responsibilities. Another incorrect approach involves making an immediate, unsubstantiated disciplinary decision based solely on the client's accusation, without allowing the associated person an opportunity to respond or conducting a thorough investigation. This violates principles of fairness and due process and could lead to wrongful disciplinary action, potentially exposing the firm to legal challenges and reputational damage. It also fails to meet the supervisory requirement of conducting a proper inquiry. Finally, deciding to take no action because the associated person is a high-revenue producer is a severe ethical and regulatory breach. FINRA rules and ethical standards apply equally to all associated persons, regardless of their production levels. Prioritizing revenue over compliance and client protection is a direct violation of supervisory duties and undermines the integrity of the firm and the securities industry. Professionals should employ a decision-making framework that prioritizes compliance, thorough investigation, and fairness. This involves 1. Acknowledging and documenting all client complaints immediately. 2. Initiating a prompt and objective investigation, which includes obtaining the associated person's perspective. 3. Consulting with compliance and legal departments for guidance. 4. Determining if a rule violation has occurred based on evidence. 5. Implementing appropriate corrective actions, which may range from additional training to disciplinary measures based on the findings and firm policy. 6. Documenting all steps taken and decisions made throughout the process. Question 6. The investigation demonstrates that a registered representative of a FINRA member firm in California has been actively trading in a volatile sector of the market using personal brokerage accounts, and there are preliminary indications that some of these trades may have occurred shortly before or after the firm executed large block trades for institutional clients in the same sector. What is the most appropriate initial step for the firm's compliance department to take in addressing this situation? Option A. Immediately initiate a detailed review of the registered representative's personal trading records, cross-referencing them with the firm's proprietary trading activity and client transactions in the relevant sector, and assess for any potential conflicts of interest or violations of firm policy and FINRA rules. Option B. Focus the initial review solely on whether the registered representative's personal trades resulted in significant profits or losses. Option C. Wait for a formal client complaint to be filed before commencing a thorough investigation into the representative's personal trading activities. Option D. Advise the registered representative to cease all personal trading activity in that sector until the investigation is complete, without conducting an immediate review of past trades. The correct answer is A. Immediately initiate a detailed review of the registered representative's personal trading records, cross-referencing them with the firm's proprietary trading activity and client transactions in the relevant sector, and assess for any potential conflicts of interest or violations of firm policy and FINRA rules. Explanation. The investigation demonstrates a scenario where a registered representative's personal trading activities have raised concerns regarding potential conflicts of interest and adherence to firm policies, directly implicating the definition of a person associated with a member under FINRA rules applicable in the United States. This situation is professionally challenging because it requires a supervisor to balance the need for thorough investigation with the rights and responsibilities of the associated person, while ensuring compliance with regulatory obligations. The core issue revolves around determining whether the individual's actions fall within the scope of activities that necessitate disclosure and oversight by the member firm. The best professional practice involves a comprehensive and proactive approach to investigating the allegations. This entails immediately reviewing the registered representative's personal trading accounts, cross-referencing these trades with any proprietary information or client accounts they may have access to, and assessing whether any transactions could be construed as a conflict of interest or a violation of the firm's policies or FINRA rules. This approach is correct because it directly addresses the potential regulatory and ethical breaches by gathering all relevant facts. FINRA Rule 3210, concerning private securities transactions of an associated person, and the general supervisory obligations under FINRA Rule 3110, require member firms to have procedures in place to supervise the activities of their associated persons, including personal trading. A thorough review ensures that the firm fulfills its duty to supervise and can identify any instances where an associated person acted outside the scope of their permitted activities or engaged in prohibited conduct. An incorrect approach would be to dismiss the allegations without a thorough review, assuming the registered representative acted appropriately. This fails to meet the firm's supervisory obligations under FINRA Rule 3110, which mandates diligent supervision of registered persons. It also ignores the potential for conflicts of interest and violations of rules like FINRA Rule 3210, which requires disclosure of private securities transactions. Another incorrect approach is to only review the registered representative's trading activity after a client complaint has been filed. While client complaints trigger investigations, proactive supervision requires addressing potential issues as they arise, even before formal complaints. This reactive stance can lead to significant regulatory sanctions and reputational damage. Finally, an incorrect approach is to focus solely on whether the trades were profitable, rather than on whether they constituted a conflict of interest or a violation of disclosure requirements. Profitability is not the primary determinant of a rule violation. The nature of the trade, its timing, and its relationship to the representative's professional duties are paramount. Professionals should approach such situations by first understanding the scope of associated person under FINRA rules, which broadly includes individuals engaged in the securities business of a member firm. When allegations arise, decision-making process should involve 1. Immediate initiation of a fact-finding inquiry, 2. Consultation with compliance and legal departments, 3. Careful documentation of all steps taken and findings, and 4. Determination of whether the activities fall under specific FINRA rules requiring disclosure, approval, or prohibition. This systematic approach ensures that regulatory obligations are met and that the firm acts in a responsible and ethical manner. Question 7. Assessment of the role of a registered representative in California who is responsible for overseeing the sales activities of other representatives involved in the trading of municipal securities, including approving their transactions and ensuring adherence to relevant regulations, would classify this individual as which of the following under FINRA rules? Option A. A senior municipal securities trader. Option B. A municipal securities sales principal. Option C. A municipal securities operations clerk. Option D. A municipal securities research analyst. The correct answer is B. A municipal securities sales principal. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a nuanced understanding of the definition of a municipal securities sales principal under FINRA rules, specifically as it applies to the state of California. Misinterpreting this definition can lead to significant regulatory violations, including improper supervision and potential disciplinary action. The challenge lies in distinguishing between individuals who merely interact with municipal securities and those who are responsible for supervising the sales activities related to them. Correct approach analysis. The correct approach involves identifying the individual whose responsibilities encompass the supervision of municipal securities sales activities. Under FINRA Rule 5310, a municipal securities sales principal is defined as a person associated with a municipal securities broker or dealer who is engaged in the management, direction, or supervision of the municipal securities sales activities of such broker or dealer. This includes individuals who approve or designate other persons to engage in such activities. Therefore, the individual who oversees the sales team's engagement with municipal bonds, approves their transactions, and ensures compliance with relevant regulations is the municipal securities sales principal. This aligns with the regulatory intent to ensure qualified individuals are responsible for the oversight of municipal securities sales to protect investors and maintain market integrity within California. Incorrect approaches analysis. An approach that focuses solely on an individual's knowledge of municipal securities or their ability to execute trades without considering their supervisory role is incorrect. For instance, a senior trader who possesses extensive knowledge of municipal bonds but does not supervise sales personnel or approve their activities does not fit the definition of a municipal securities sales principal. Similarly, an individual who only provides research or analytical support on municipal securities without any direct oversight of sales efforts would not qualify. Finally, an individual who handles back-office operations related to municipal securities, such as clearing and settlement, but has no involvement in the sales process or its supervision, also falls outside the definition. These approaches fail to recognize the core supervisory and managerial duties inherent in the definition of a municipal securities sales principal as established by FINRA and applicable to firms operating in California. Professional reasoning. Professionals should approach this by first consulting the specific FINRA rule defining the role of a municipal securities sales principal. They must then carefully analyze an individual's job description, duties, and responsibilities, looking for evidence of management, direction, or supervision of municipal securities sales activities. If there is any ambiguity, seeking clarification from compliance departments or regulatory bodies is essential. The focus should always be on the functional responsibilities rather than titles or general knowledge. Question 8. The efficiency study reveals that a registered representative in your New York branch office may have an undisclosed association with an individual who is currently undergoing a FINRA statutory disqualification proceeding. What is the most appropriate immediate course of action for the branch manager to take? Option A. Proceed with terminating the registered representative's employment pending the outcome of the statutory disqualification proceeding. Option B. Allow the association to continue while passively monitoring the outcome of the statutory disqualification proceeding. Option C. Immediately initiate a thorough internal investigation to determine the nature and extent of the association and the specifics of the statutory disqualification proceeding, consulting with the firm's compliance department and legal counsel. Option D. Advise the registered representative to cease all contact with the individual immediately and document this instruction. The correct answer is C. Immediately initiate a thorough internal investigation to determine the nature and extent of the association and the specifics of the statutory disqualification proceeding, consulting with the firm's compliance department and legal counsel. Explanation. The efficiency study reveals a potential conflict of interest and regulatory concern regarding a registered representative's association with an entity that may be subject to statutory disqualification. This scenario is professionally challenging because it requires a supervisor to balance the firm's operational needs with its stringent regulatory obligations, particularly concerning the integrity of the securities markets and investor protection. The supervisor must act proactively to prevent potential violations of FINRA rules, which are designed to safeguard the public and maintain confidence in the financial industry. The best professional approach involves immediately initiating a thorough investigation into the nature and extent of the association and the potential statutory disqualification. This includes gathering all relevant documentation, interviewing the representative, and consulting with the firm's compliance department and legal counsel. The firm must then take appropriate action based on the findings, which could range from severing ties with the individual or entity to seeking regulatory approval for the association, if permissible. This approach is correct because it directly addresses the potential regulatory risk by adhering to FINRA Rule 3110, Supervision, and FINRA Rule 3150, Supervision of associated persons seeking employment with a member firm. These rules mandate that member firms establish and maintain a supervisory system reasonably designed to supervise the activities of their associated persons and to prevent violations of the federal securities laws and FINRA rules. Proactively investigating and addressing potential statutory disqualifications demonstrates a commitment to compliance and investor protection, which are paramount ethical and regulatory duties. An incorrect approach would be to dismiss the findings of the efficiency study without further inquiry, assuming the representative has already disclosed any relevant associations. This is professionally unacceptable because it abdicates the supervisor's responsibility to ensure compliance and could lead to the firm being associated with a statutorily disqualified person, violating FINRA Rule 3110 and potentially exposing the firm and its customers to significant risk. Another incorrect approach is to allow the association to continue while passively waiting for a regulatory inquiry. This is also professionally unacceptable as it demonstrates a lack of due diligence and a failure to proactively manage regulatory risk. FINRA rules require member firms to have systems in place to prevent such associations, not merely to react to them. Finally, an incorrect approach would be to immediately terminate the representative's association without a proper investigation or consultation with compliance and legal. While decisive action might seem appropriate, it could be premature and potentially lead to legal challenges if the statutory disqualification is not confirmed, or if the association could have been permissible under specific circumstances with appropriate disclosures and approvals. The professional reasoning process should involve a systematic evaluation of the information, consultation with internal experts, and adherence to established compliance procedures to ensure a fair and regulatory compliant outcome. Question 9. Regulatory review indicates that a registered representative in California has received a notice of intent to censure and impose a fine from the Financial Industry Regulatory Authority, FINRA, concerning alleged violations of suitability rules. What is the most appropriate immediate course of action for the employing broker-dealer firm? Option A. Immediately terminate the registered representative's employment to demonstrate the firm's zero-tolerance policy towards regulatory violations. Option B. Place the registered representative on an indefinite administrative leave of absence without informing them of the specific FINRA allegations, pending the outcome of FINRA investigation. Option C. Forward the FINRA notice to the registered representative's personal attorney and await their instructions before taking any internal action. Option D. Initiate a prompt and thorough internal investigation into the allegations. Inform the registered representative of the FINRA notice and the specific allegations, and provide them with an opportunity to respond internally while cooperating fully with FINRA inquiry. The correct answer is D. Initiate a prompt and thorough internal investigation into the allegations. Inform the registered representative of the FINRA notice and the specific allegations, and provide them with an opportunity to respond internally while cooperating fully with FINRA inquiry. Explanation. Regulatory review indicates a scenario where a registered representative's conduct has triggered a potential disciplinary action by the Financial Industry Regulatory Authority, FINRA, in the United States. This situation is professionally challenging because it involves balancing the firm's obligation to supervise with the representative's right to due process, while also safeguarding the integrity of the securities markets and protecting investors. The firm must act decisively but fairly, adhering strictly to FINRA rules and federal securities laws. Correct approach involves immediately initiating a thorough internal investigation upon receiving notification of the potential disciplinary action. This investigation should be conducted promptly and impartially, gathering all relevant facts, documentation, and statements from the representative and any other involved parties. Simultaneously, the firm must notify the registered representative of the specific allegations and provide them with an opportunity to respond, as required by FINRA Rule 8210 and other relevant supervisory rules. This proactive and compliant response demonstrates the firm's commitment to regulatory obligations and allows for a well-informed decision regarding further actions, such as placing the representative on a required leave of absence or implementing enhanced supervision, pending the outcome of the FINRA investigation. This aligns with the ethical duty to supervise and the regulatory imperative to address potential misconduct. An incorrect approach would be to ignore the notification or delay the internal investigation. This failure to act promptly violates FINRA supervisory requirements and could be interpreted as an attempt to circumvent regulatory oversight. It also deprives the registered representative of their right to be informed and respond to allegations in a timely manner, potentially prejudicing their defense. Another incorrect approach would be to immediately terminate the registered representative's employment without a thorough internal investigation or providing them an opportunity to respond to the allegations. While termination may ultimately be necessary, doing so prematurely based solely on a regulatory notification without due process can lead to legal challenges and may not fully address the nuances of the situation or the firm's supervisory responsibilities. Finally, an incorrect approach would be to only communicate with FINRA and not conduct an internal investigation or inform the registered representative of the allegations. This passive stance abdicates the firm's primary responsibility for supervision and fails to uphold the principles of fairness and due process for the employee. Professionals should approach such situations by first understanding the specific allegations and the regulatory body involved. They must then consult the firm's internal policies and procedures, as well as relevant FINRA rules and federal securities laws. A structured approach involving prompt investigation, clear communication with the representative, and collaboration with legal and compliance departments is crucial for navigating these complex situations effectively and ethically. Question. Regulatory review indicates that a registered representative in California has received a notice of intent to censure and impose a fine from the Financial Industry Regulatory Authority, FINRA, concerning alleged violations of suitability rules. What is the most appropriate immediate course of action for the employing broker-dealer firm? Options. A. Initiate a prompt and thorough internal investigation into the allegations. Inform the registered representative of the FINRA notice and the specific allegations, and provide them with an opportunity to respond internally while cooperating fully with FINRA inquiry. B. Immediately terminate the registered representative's employment to demonstrate the firm's zero-tolerance policy towards regulatory violations. C. place the registered representative on an indefinite administrative leave of absence without informing them of the specific FINRA allegations, pending the outcome of FINRA investigation. D. Forward the FINRA notice to the registered representative's personal attorney and await their instructions before taking any internal action. Question 10. Consider a scenario in New York where a registered principal receives a written customer complaint alleging that a security was misrepresented, leading to a loss. The customer purchased 100 shares of XYZ Corp at $50.00 per share. The current market value of XYZ Corp is $35.00 per share. The principal must determine the financial impact of the alleged misrepresentation and initiate the required supervisory actions. According to FINRA Rule 4513, written complaints must be forwarded to a principal within 5 business days of receipt. What is the minimum financial loss to be considered in the investigation, and what is the primary regulatory imperative regarding the complaint's handling? Option A. The minimum financial loss is $1,500,000, and the primary regulatory imperative is to inform the customer that the firm is not liable for market fluctuations. Option B. The minimum financial loss is $5,000,000, and the primary regulatory imperative is to escalate the complaint to the sales representative's manager immediately. Option C. The minimum financial loss is $5,000,000, and the primary regulatory imperative is to wait for the customer to provide further documentation before initiating any investigation. Option D. The minimum financial loss is $1,500,000, and the primary regulatory imperative is to promptly investigate and document the complaint in accordance with FINRA Rule 4513. The correct answer is D. The minimum financial loss is $1,500,000, and the primary regulatory imperative is to promptly investigate and document the complaint in accordance with FINRA Rule 4513. Explanation. Scenario analysis. This scenario presents a common challenge for Series 9 and 10 registered principals, ensuring compliance with FINRA rules regarding supervision and record keeping, specifically concerning the handling of customer complaints. The principal must balance the need for thorough investigation with the regulatory requirement for timely action and accurate documentation. Failure to do so can result in disciplinary action, reputational damage, and financial penalties. The mathematical element introduces a layer of complexity, requiring precise calculation and adherence to specific timeframes. Correct approach analysis. The best approach involves a systematic and compliant process. Upon receiving the complaint, the principal must immediately initiate a review. This includes calculating the potential financial impact of the complaint, which in this case involves determining the difference between the purchase price and the current market value of the security. The formula for this is /text loss equals /text purchase price /text current market value times /text number of shares /. In this scenario, the loss is $50,00 $35,00 times 100 text shares equals $15,00 times 100 equals $1 500 FINRA Rule 4513 requires that all written customer complaints be forwarded to the principal within 5 business days of receipt. The principal must then conduct a thorough investigation, which may involve reviewing account statements, trading records, and communications with the customer. The outcome of the investigation, including any resolution or proposed action, must be documented and reported as required by FINRA rules. This comprehensive and timely approach ensures regulatory compliance and demonstrates diligent supervision. Incorrect approaches analysis. One incorrect approach involves delaying the calculation of the financial impact and the formal investigation until after the initial 5 business day window has passed. This violates FINRA Rule 4513, which mandates the prompt forwarding of complaints to a principal for review. The delay in calculating the potential loss also hinders the ability to assess the severity of the complaint and prioritize resources effectively. Another incorrect approach is to only verbally acknowledge the complaint and not initiate any formal investigation or documentation. FINRA rules require written records of customer complaints and the actions taken. Verbal acknowledgments are insufficient for compliance and do not provide a clear audit trail for supervisory review. This approach also fails to address the financial impact calculation, which is crucial for understanding the scope of the issue. A third incorrect approach is to dismiss the complaint without a thorough investigation, based solely on the initial information provided by the sales representative. FINRA rules require principals to conduct independent investigations into customer complaints, not to rely solely on the perspective of the employee involved. This failure to investigate independently is a direct violation of supervisory responsibilities. Professional reasoning. Professionals should approach customer complaints with a structured process that prioritizes regulatory compliance and customer satisfaction. This involves immediate acknowledgement, prompt calculation of any potential financial impact using precise formulas, thorough and independent investigation, and meticulous record keeping. When faced with a complaint involving financial calculations, it is essential to apply the correct formulas and adhere strictly to the defined timeframes for reporting and action as stipulated by FINRA rules. This systematic approach ensures that all regulatory obligations are met and that customer concerns are addressed professionally and effectively. Question 11. Upon reviewing the activity of a newly registered municipal securities representative in Ontario, Canada, who has recently passed their licensing examinations, what is the most appropriate supervisory action for a municipal securities principal to take regarding their initial municipal bond transactions? Option A. Prioritize the volume of municipal securities transactions the representative can execute, offering minimal oversight as long as the deals are completed. Option B. Proactively review each proposed municipal securities transaction, focusing on the underlying security, client suitability, and disclosure requirements, and provide guidance to the representative. Option C. Assume the representative is fully capable of independently managing all municipal securities transactions due to their successful completion of licensing exams. Option D. Delegate the complete oversight of the representative's municipal securities activities to a senior salesperson without direct principal involvement. The correct answer is B. Proactively review each proposed municipal securities transaction, focusing on the underlying security, client suitability, and disclosure requirements, and provide guidance to the representative. Explanation. This scenario presents a professional challenge because it requires a municipal securities principal to balance the firm's compliance obligations with the potential for revenue generation, while also ensuring that a newly registered representative understands and adheres to the stringent regulations governing municipal securities. The principal's judgment is critical in determining the appropriate level of supervision and guidance without stifling the representative's development or creating undue risk for the firm. The correct approach involves the principal actively engaging with the new representative to review their proposed municipal securities transactions, focusing on understanding the underlying securities, the suitability of the recommendations for the specific clients, and ensuring all disclosure requirements are met. This proactive and educational oversight is crucial. Specifically, it aligns with FINRA Rule 3110, Supervision, and the Municipal Securities Rulemaking Board, MSRB, Rule G27, Supervision of Principals and Salespersons. These rules mandate that principals must supervise the activities of their registered representatives, ensuring that transactions are suitable and that all regulatory requirements, including disclosure and record keeping, are followed. By reviewing the transactions and providing guidance, the principal directly fulfills their supervisory duty and educates the representative on best practices and regulatory expectations in the municipal securities market. An incorrect approach would be to assume the new representative, having passed the licensing exam, is fully equipped to handle all municipal securities transactions independently. This overlooks the practical application of knowledge and the specific nuances of municipal securities, which often require deeper understanding than a licensing exam can fully impart. This failure to provide adequate supervision violates FINRA Rule 3110 and MSRB Rule G27, potentially exposing the firm and clients to significant risks. Another incorrect approach would be to delegate the entire oversight of the new representative's municipal securities activities to a senior salesperson without direct principal involvement. While senior salespeople can offer valuable mentorship, the ultimate supervisory responsibility rests with the principal. This abdication of responsibility is a clear breach of FINRA and MSRB rules, as it bypasses the designated supervisory structure and can lead to inconsistent or inadequate oversight. A further incorrect approach would be to focus solely on the volume of transactions the new representative can generate, offering minimal oversight as long as the transactions appear to be closing. This prioritizes revenue over compliance and client protection, which is fundamentally contrary to the principles of responsible security supervision. Such an approach ignores the core mandate of ensuring suitability and adherence to all regulatory requirements, creating a high risk of compliance violations and potential harm to investors. Professionals should approach situations involving new representatives in specialized areas like municipal securities with a framework that emphasizes education, proactive supervision, and a thorough understanding of regulatory obligations. This involves 1. Assessing the representative's current knowledge and experience, 2. Establishing clear supervisory protocols tailored to the specific product area, 3. Conducting regular reviews of transactions and client interactions, and 4. Providing ongoing training and feedback to ensure compliance and promote best practices. The goal is to foster competence and adherence to regulations, not merely to process transactions. Question 12. When evaluating the use of ownership information obtained in a fiduciary or agency capacity by a registered representative in California, which of the following actions demonstrates the most appropriate adherence to regulatory and ethical standards? Option A. Utilize the ownership information for personal investment purposes if the information is not explicitly marked as confidential. Option B. Share ownership information with other clients if it is believed that such information could lead to profitable investment opportunities for them. Option C. Disclose the ownership information to colleagues within the firm for general discussion and potential market insights. Option D. Refrain from using or disclosing any ownership information obtained through a fiduciary or agency relationship unless explicit client consent is obtained and firm policies are followed. The correct answer is D. Refrain from using or disclosing any ownership information obtained through a fiduciary or agency relationship unless explicit client consent is obtained and firm policies are followed. Explanation. When evaluating the use of ownership information obtained in a fiduciary or agency capacity, a registered representative faces a significant professional challenge due to the inherent conflict between their duty to their client and the potential for personal gain or the misuse of sensitive information. The core of this challenge lies in maintaining client confidentiality and avoiding any appearance of impropriety, which is paramount in upholding trust and adhering to regulatory standards. The Series 9 and 10 exams emphasize that supervisors must ensure their registered representatives understand and apply these principles rigorously. The correct approach involves strictly adhering to the principle that information obtained solely because of a fiduciary or agency relationship is confidential and cannot be used for personal benefit or shared with others without explicit client consent. This means that if a representative learns about a client's potential investment in a private placement through their role as a financial advisor, they cannot then use that information to recommend the same investment to other clients or to invest their own funds, unless such actions are clearly disclosed and permitted by the client and the firm, and do not violate any regulations. The regulatory framework, particularly FINRA rules, prohibits the misuse of non-public information obtained in a fiduciary capacity. This prohibition is designed to prevent insider trading and to ensure that all clients are treated fairly and that no client's confidential information is exploited. An incorrect approach would be to assume that because the information is not explicitly marked confidential, it can be shared or used. This fails to recognize the implicit duty of confidentiality that arises from a fiduciary or agency relationship. Another incorrect approach is to believe that if the information is publicly available elsewhere, its use is permissible. While the information might eventually become public, using it while it is still non-public and obtained through a fiduciary capacity is a violation. Furthermore, attempting to justify the use of such information by claiming it benefits other clients is also problematic. While a supervisor's duty is to their firm and its clients, this duty does not supersede the obligation to protect the confidentiality of information obtained from a specific client in a fiduciary capacity. Such actions can lead to regulatory sanctions, reputational damage, and loss of client trust. Professionals should employ a decision-making framework that prioritizes client interests and regulatory compliance. This involves asking, was this information obtained because of my fiduciary or agency relationship with a client? If the answer is yes, then the information is presumed confidential, and its use or dissemination is restricted unless explicit, informed consent is obtained from the client and the firm's policies are followed. When in doubt, the safest and most ethical course of action is to refrain from using the information and to consult with compliance or legal departments. Question 13. The analysis reveals that a registered representative in California has been engaging in a pattern of unauthorized trading in multiple client accounts, leading to significant client complaints and potential financial losses. As the direct supervisor, what is the most appropriate and regulatory compliant course of action to address this situation? Option A. Advise the representative to cease unauthorized trading and instruct them to contact clients to rectify any losses without formal reporting. Option B. Address the issue directly with the representative, issue a verbal warning, and monitor their activity more closely without involving compliance. Option C. Immediately report the suspected violations to the firm's compliance department and initiate a thorough internal investigation under their guidance. Option D. Terminate the representative's employment immediately and handle any client complaints internally without reporting to regulatory bodies. The correct answer is C. Immediately report the suspected violations to the firm's compliance department and initiate a thorough internal investigation under their guidance. Explanation. The analysis reveals a scenario where a registered representative, Sarah, has engaged in a pattern of unauthorized trading in client accounts, a clear violation of FINRA rules and securities regulations in California. This situation is professionally challenging because it involves not only a breach of trust with clients, but also potential financial harm to them and significant reputational damage to the firm. The firm's compliance department must act decisively to address the violations, protect clients, and uphold regulatory standards. The best approach involves Sarah's supervisor immediately reporting the suspected violations to the firm's compliance department and initiating a thorough internal investigation. This is correct because FINRA Rule 3010 requires supervisors to establish and maintain a supervisory system reasonably designed to achieve compliance with applicable securities laws and regulations. Prompt reporting to compliance ensures that the firm can fulfill its supervisory obligations, conduct a proper investigation, and take appropriate disciplinary action as mandated by FINRA Rule 8310, which outlines sanctions for rule violations. This also aligns with the ethical duty of care owed to clients and the firm's responsibility to maintain a compliant operational environment. An incorrect approach would be for the supervisor to attempt to resolve the issue informally with Sarah without involving the compliance department. This is professionally unacceptable because it bypasses the firm's established procedures for handling potential rule violations, potentially shielding Sarah from necessary disciplinary action, and failing to adequately protect clients. It also violates the supervisor's duty to report such matters to compliance, as required by firm policy and FINRA regulations. Another incorrect approach would be to immediately terminate Sarah's employment without a proper investigation and without reporting the matter to FINRA. While termination may be an eventual outcome, doing so prematurely without due process and without fulfilling reporting obligations is a regulatory failure. FINRA Rule 8310 mandates that violations be addressed through the appropriate disciplinary channels, which includes reporting to FINRA. Failure to do so can result in further sanctions against the firm. A final incorrect approach would be to simply issue a verbal warning to Sarah and continue to monitor her activity without a formal investigation or documentation. This is professionally unacceptable as it does not constitute a robust supervisory response. It fails to address the severity of unauthorized trading, does not create a record of the violation, and does not ensure that appropriate remedial actions or sanctions are applied, thereby undermining the firm's compliance program and potentially exposing the firm to future regulatory scrutiny. Professionals should approach such situations by prioritizing adherence to regulatory requirements and ethical obligations. This involves a clear understanding of supervisory responsibilities, a commitment to prompt and accurate reporting, and a dedication to conducting thorough investigations. When potential violations are identified, the decision-making process should focus on protecting clients, upholding the integrity of the securities markets, and ensuring the firm's compliance with all applicable rules and regulations. Question 14. Operational review demonstrates that a registered representative associated with a FINRA member firm in California has accepted a position as a director for a privately held company that provides consulting services to startups, some of which are seeking venture capital funding. The representative has not yet disclosed this directorship to their firm. Under FINRA regulations, what is the most appropriate course of action for the representative? Option A. Assume that since the private company is not a registered broker-dealer and does not directly sell securities, disclosure is not required. Option B. Only disclose the directorship if the private company begins to engage in activities that directly involve the sale of securities. Option C. Immediately disclose the directorship and all relevant details of the private company's business and the representative's role to their employing firm for review. Option D. Wait to disclose the directorship until the firm specifically asks about outside business activities or directorships. Correct answer is C. Immediately disclose the directorship and all relevant details of the private company's business and the representative's role to their employing firm for review. Explanation. This scenario is professionally challenging because it requires a registered representative to balance their primary employment obligations with potential conflicts of interest arising from outside business activities. The FINRA rules, specifically Rule 3270, mandate that registered persons disclose any outside business activities to their member firm. This disclosure is crucial for the firm to assess potential conflicts, ensure compliance with securities regulations, and protect both the firm and the public. The representative's failure to disclose a directorship in a private company, especially one that might engage in activities related to the securities industry, creates a significant compliance risk. The best professional approach involves immediate and full disclosure of the outside business activity to the employing firm. This includes providing all relevant details about the nature of the directorship, the company's business, and the representative's role. Upon receiving this information, the firm can then conduct its own review to determine if the activity poses a conflict of interest, if it requires additional supervision, or if it is prohibited. This proactive disclosure aligns with the ethical obligation to act with integrity and uphold regulatory requirements, ensuring transparency and allowing the firm to fulfill its supervisory responsibilities under FINRA Rule 3270. An incorrect approach involves assuming that because the private company is not publicly traded or directly involved in selling securities, disclosure is unnecessary. This overlooks the broad definition of outside business activity under FINRA rules, which encompasses any business or employment activity outside of the registered person's association with their member firm. Another incorrect approach is to only disclose the activity if directly asked by the firm. FINRA Rule 3270 places the onus on the registered person to proactively disclose, not to wait for an inquiry. Finally, attempting to downplay the significance of the directorship or its potential implications is also professionally unacceptable. This demonstrates a lack of understanding of the regulatory intent behind disclosure requirements, which is to identify and manage potential conflicts of interest before they materialize into violations. Professionals should adopt a decision-making framework that prioritizes transparency and adherence to regulatory mandates. When considering any activity outside of their registered role, they should ask, does this activity fall under the definition of an outside business activity as defined by FINRA? If the answer is even potentially yes, the default action should be to disclose it to their firm immediately and in full. This proactive stance minimizes compliance risks and fosters a culture of integrity within the financial services industry. Question: Operational review demonstrates that a registered representative associated with a FINRA member firm in California has accepted a position as a director for a privately held company that provides consulting services to startups, some of which are seeking venture capital funding. The representative has not yet disclosed this directorship to their firm. Under FINRA regulations, what is the most appropriate course of action for the representative? Options: A. Immediately disclose the directorship and all relevant details of the private company's business and the representative's role to their employing firm for review. B. Assume that since the private company is not a registered broker-dealer and does not directly sell securities, disclosure is not required. C. Wait to disclose the directorship until the firm specifically asks about outside business activities or directorships. D. Only disclose the directorship if the private company begins to engage in activities that directly involve the sale of securities. Question 15. Implementation of a new operational structure within a New York-based broker-dealer has resulted in several experienced registered representatives taking on expanded responsibilities that involve overseeing the work of junior colleagues and approving certain client communications. The Chief Compliance Officer, CCO, is aware that these individuals have not yet completed the Series 9 and 10 examinations required for principals. What is the most appropriate course of action for the CCO to ensure compliance with FINRA registration requirements? Option A. Allow the individuals to continue performing their expanded duties while initiating the registration process, with the understanding that they will complete the required exams within 90 days. Option B. Permit the individuals to continue supervising junior colleagues and approving communications, as their extensive experience in the industry compensates for the lack of formal principal registration. Option C. Immediately assign the individuals to non-supervisory roles until they successfully complete the Series 9 and 10 examinations and are registered as principals. Option D. Reclassify the individuals' roles to team leads or mentors to avoid triggering formal principal registration requirements, as these titles do not explicitly denote supervisory authority. Correct answer is C. Immediately assign the individuals to non-supervisory roles until they successfully complete the Series 9 and 10 examinations and are registered as principals. Explanation: this scenario presents a professional challenge because it requires a supervisor to balance the firm's operational needs with the stringent registration requirements mandated by FINRA for individuals performing supervisory functions. The core of the challenge lies in ensuring that all individuals acting in a supervisory capacity are properly registered, a fundamental aspect of investor protection and regulatory compliance. Failure to do so can result in significant regulatory penalties and reputational damage. The correct approach involves proactively identifying individuals who are performing supervisory duties and ensuring they have completed the necessary registration process, including passing the appropriate examinations. This means that before or immediately upon assuming supervisory responsibilities, the individual must hold the required licenses and registrations. This aligns with FINRA Rule 1210, which dictates that no member or person associated with a member shall function as a principal, unless such person is registered in the capacity of a principal. This proactive stance ensures that supervisory oversight is always conducted by qualified and registered individuals, thereby upholding regulatory standards and protecting investors. An incorrect approach would be to allow an individual to continue performing supervisory duties without the requisite registration, assuming that the registration process will be completed at some point in the future. This violates FINRA Rule 1210 by permitting an unregistered person to act as a principal. The regulatory framework does not permit a grace period for assuming supervisory roles. Registration must be current. Another incorrect approach is to interpret the role of assistant supervisor as exempt from registration requirements. FINRA rules are broad in their definition of supervisory functions. If an individual is exercising supervisory authority or responsibility, regardless of their title, they are subject to registration requirements. Failing to register such an individual is a direct contravention of the rules. Finally, an incorrect approach would be to delay the registration process for an individual who has recently been promoted to a supervisory role, citing workload or administrative delays. While administrative challenges can occur, they do not supersede the regulatory mandate for registration. The responsibility lies with the firm and the individual to ensure timely compliance with registration requirements before or concurrently with the assumption of supervisory duties. Professionals should adopt a decision-making framework that prioritizes regulatory compliance. This involves a thorough understanding of FINRA registration rules, particularly Rule 1210, and implementing robust internal processes to track and manage the registration status of all personnel, especially those in or transitioning to supervisory roles. Regular audits and clear communication channels between compliance, human resources, and management are essential to identify and address potential registration gaps proactively. Question 16. To address the challenge of an associated person's involvement in an investment opportunity outside their firm's offerings, what is the most appropriate course of action under FINRA Rule 3280 for an individual registered with a FINRA member firm in California? Option A. The associated person should inform their employing firm about the transaction only after it has been fully completed. Option B. The associated person can proceed with the investment without notifying their employing firm, as it is a personal investment and not part of their official duties. Option C. The associated person must provide prior written notice to their employing firm detailing the proposed transaction and their role, and await the firm's written approval before participating, especially if selling compensation is involved, in which case the firm must also have procedures for adequate supervision. Option D. The associated person should seek approval for the private securities transaction from another FINRA member firm, where they are not employed. The correct answer is C. The associated person must provide prior written notice to their employing firm detailing the proposed transaction and their role, and await the firm's written approval before participating, especially if selling compensation is involved, in which case the firm must also have procedures for adequate supervision. Explanation: this scenario presents a professional challenge because it involves an associated person engaging in a private securities transaction outside of their regular employment with a FINRA member firm. The core issue is ensuring compliance with FINRA Rule 3280, which governs private securities transactions, and maintaining the integrity of the firm's supervision and the public trust. The associated person's desire to participate in an investment opportunity that is not offered by their employer necessitates a clear understanding of their disclosure and approval obligations. Failure to adhere to these rules can lead to significant regulatory sanctions, reputational damage for both the individual and the firm, and potential harm to investors. The correct approach involves the associated person providing prior written notice to their employing firm regarding the proposed private securities transaction. This notice must include a detailed description of the proposed transaction, the associated person's intended role, and whether they will receive any selling compensation. Upon receiving this notice, the employing firm must review the transaction and provide written approval or disapproval. If selling compensation is involved, the firm must have procedures in place to supervise the transaction adequately. This approach is correct because it directly aligns with the requirements of FINRA Rule 3280, which mandates disclosure and firm approval to ensure that such transactions are conducted in compliance with securities laws and regulations, and that the firm can effectively supervise its associated persons. It prioritizes transparency and regulatory adherence, safeguarding both the firm and its clients. An incorrect approach would be for the associated person to proceed with the transaction without informing their employing firm, believing that since it is a personal investment and not part of their job duties, no notification is required. This fails to meet the explicit disclosure requirements of FINRA Rule 3280 and undermines the firm's supervisory responsibilities. Another incorrect approach would be to inform the firm only after the transaction has been completed. This violates the prior written notice requirement and prevents the firm from exercising its supervisory duties before the transaction occurs, potentially exposing the firm and the associated person to regulatory scrutiny. Finally, an associated person seeking approval from a different FINRA member firm for the transaction, rather than their own employing firm, would also be incorrect. FINRA Rule 3280 clearly places the responsibility for notification and approval on the associated person's current employer. Professionals should approach situations involving private securities transactions by first thoroughly understanding the definition of a private securities transaction under FINRA Rule 3280. They must then proactively communicate with their employing firm, providing all necessary information in writing and seeking the required approvals before engaging in any such activity. This proactive and transparent approach is crucial for maintaining regulatory compliance and ethical conduct. Question: to address the challenge of an associated person's involvement in an investment opportunity outside their firm's offerings, what is the most appropriate course of action under FINRA Rule 3280 for an individual registered with a FINRA member firm in California? Options: A. The associated person must provide prior written notice to their employing firm detailing the proposed transaction and their role, and await the firm's written approval before participating, especially if selling compensation is involved, in which case the firm must also have procedures for adequate supervision. B. The associated person can proceed with the investment without notifying their employing firm, as it is a personal investment and not part of their official duties. C. The associated person should inform their employing firm about the transaction only after it has been fully completed. D. the associated person should seek approval for the private securities transaction from another FINRA member firm, where they are not employed. Question 17. Examination of the data shows that a registered representative's proposed variable contract compensation plan from an affiliated insurance company is being submitted for supervisor approval in California. The plan outlines commission rates that vary based on the type and volume of variable annuity contracts sold. What is the most appropriate action for the supervisor to take to ensure compliance with FINRA regulations regarding member compensation for variable contracts? Option A. Review the compensation plan to determine if any commission structures create an incentive for the representative to recommend specific variable contracts or engage in excessive trading, and assess if the overall compensation is fair and reasonable in relation to the services provided and the products sold. Option B. Approve the compensation plan immediately, as it is a standard offering from the affiliated insurance company and has likely been vetted by their internal compliance department. Option C. Focus solely on the total potential earnings outlined in the plan to ensure the representative is adequately compensated, without scrutinizing the specific commission percentages or structures. Option D. Forward the compensation plan to the insurance company's legal department for their final review and approval, assuming their assessment will guarantee FINRA compliance. Correct answer is A. Review the compensation plan to determine if any commission structures create an incentive for the representative to recommend specific variable contracts or engage in excessive trading, and assess if the overall compensation is fair and reasonable in relation to the services provided and the products sold. Explanation. This scenario presents a professional challenge because it requires a supervisor to navigate the complexities of variable contract compensation structures while ensuring compliance with FINRA regulations and upholding ethical standards for registered representatives. The core difficulty lies in distinguishing between permissible sales-based compensation and potentially problematic incentives that could lead to unsuitable recommendations or excessive trading. Careful judgment is required to assess the intent and impact of compensation arrangements on client interests. The correct approach involves a thorough review of the variable contract compensation plan to identify any provisions that directly link compensation to the sale of specific variable products, or that create an undue incentive for representatives to churn accounts or recommend products that are not in the client's best interest. This approach is correct because FINRA Rule 2320G mandates that member compensation for variable contracts must be fair and reasonable, and not provide an incentive for representatives to recommend variable contracts over other suitable investments. By scrutinizing the plan for such incentives, the supervisor is proactively identifying and mitigating potential compliance risks and ethical breaches, ensuring that compensation structures do not compromise the duty of care owed to clients. This aligns with the overarching principle of putting the customer's interests first. An incorrect approach would be to approve the compensation plan solely because it is a standard offering from the insurance company. This is professionally unacceptable because it abdicates the supervisor's responsibility to independently assess the plan's compliance with FINRA rules. The fact that a plan is standard does not automatically make it compliant or ethical, especially when it comes to variable contracts where the potential for conflicts of interest is high. Another incorrect approach would be to focus only on the total dollar amount of compensation, without examining how that compensation is structured. This is professionally unacceptable because the structure of compensation, not just the amount, is critical in identifying potential incentives for unsuitable sales practices. A seemingly reasonable total compensation could be derived from a structure that heavily rewards volume or specific product sales, thereby creating an incentive to prioritize sales over client suitability. Finally, an incorrect approach would be to assume that if the insurance company's internal compliance department has approved the plan, then it is automatically compliant with FINRA regulations. This is professionally unacceptable because the firm's internal compliance is a first line of defense, but the ultimate responsibility for ensuring compliance with FINRA rules rests with the registered principal and the firm. The supervisor must exercise independent judgment and cannot rely solely on another department's approval without their own due diligence. Professionals should adopt a decision-making framework that prioritizes a proactive and diligent review of all compensation structures related to variable contracts. This involves understanding the specific requirements of FINRA Rule 2320G, critically evaluating how compensation is earned, and always considering the potential impact on client interests and suitability. When in doubt, seeking clarification from compliance or legal departments, or even consulting FINRA guidance, is a prudent step. Question 18. Research into a registered representative's compliance obligations in Ontario reveals they have an outstanding monetary sanction imposed by the Ontario Securities Commission (OSC) that remains unpaid. As a supervisor, what is the most appropriate course of action to ensure both the representatives and the firm's adherence to regulatory requirements? Option A. Facilitate the representative's prompt payment of the OSC sanction, exploring permissible payment arrangements if necessary, and ensure proper reporting of the resolution to the OSC. Option B. Recommend the representative ignore the outstanding sanction, as it is a personal debt and not directly the firm's responsibility. Option C. Suggest the representative seek a personal loan from colleagues within the firm to cover the outstanding sanction. Option D. Advise the representative to cease all registered activities in Ontario until the sanction is resolved, without actively assisting in its payment. Correct answer is A. Facilitate the representative's prompt payment of the OSC sanction, exploring permissible payment arrangements if necessary, and ensure proper reporting of the resolution to the OSC. Explanation. This scenario presents a professional challenge because a registered representative has incurred a significant monetary sanction from a regulatory body, and their ability to continue in the securities industry in Ontario is directly impacted by their compliance with payment obligations. The challenge lies in navigating the regulatory requirements for handling such situations to ensure both the representative's compliance and the firm's adherence to its supervisory responsibilities under Ontario securities law. Careful judgment is required to avoid actions that could exacerbate the situation or lead to further regulatory scrutiny. The best professional approach involves proactively addressing the outstanding fine by facilitating its payment in accordance with the Ontario Securities Commission (OSC) rules. This includes understanding the specific requirements for payment, potentially assisting the representative in establishing a payment plan if permissible, and ensuring the firm reports the resolution of the sanction to the OSC as required. This approach is correct because it directly confronts the regulatory obligation, demonstrates good faith compliance, and mitigates further risk to both the representative and the firm. It aligns with the principle of upholding the integrity of the Ontario securities market by ensuring that individuals subject to monetary sanctions fulfill their obligations. An incorrect approach would be to ignore the outstanding fine, or to advise the representative to delay payment indefinitely. This is professionally unacceptable because it directly violates the spirit and letter of OSC Rule 8320, which mandates the payment of fines and other monetary sanctions. Such inaction could lead to further disciplinary action against the representative, including potential suspension or bar from the industry, and could also result in sanctions against the firm for failure to supervise. Another incorrect approach would be to suggest the representative simply cease all registered activity in Ontario without resolving the outstanding sanction. While this might temporarily remove the representative from the firm's direct supervision in Ontario, it does not absolve them of their obligation to pay the fine. Furthermore, it could be viewed as an attempt to circumvent regulatory requirements, potentially leading to more severe consequences if discovered. The OSC has mechanisms to pursue outstanding sanctions even if an individual is no longer registered in the province. A final incorrect approach would be to advise the representative to seek a personal loan from firm employees to cover the fine. This is ethically problematic and potentially violates firm policies and FINRA rules, if applicable to the firm's structure, though the focus here is Ontario regulation regarding lending to clients or associated persons, and it does not address the core regulatory requirement of payment to the OSC. It also creates a conflict of interest and could be perceived as an attempt to improperly influence the resolution of a regulatory matter. Professionals should approach such situations by first thoroughly understanding the specific regulatory requirements of the Ontario Securities Commission regarding payment of fines and sanctions. This involves consulting the relevant OSC rules and guidance. The next step is to communicate clearly and transparently with the representative about their obligations and the potential consequences of noncompliance. if permissible. The firm should explore options for assisting the representative in fulfilling their payment obligations, such as facilitating communication with the OSC regarding payment plans. Throughout this process, maintaining accurate records and ensuring timely reporting to the regulator are paramount. Question 19. Which approach would be most appropriate for a branch manager in California to ensure that a newly hired associate, who will be involved in client communications and the sale of securities, meets all qualification requirements before commencing their duties? Option A. Accept the applicant's resume and self-reported qualifications, assuming that the firm's general background check will confirm their suitability for the role. Option B. Directly access and review the individual's FINRA registration status and any required California state licenses through official regulatory databases before allowing them to engage in any securities-related activities. Option C. Allow the new hire to begin performing administrative tasks that support the sales team while awaiting confirmation of their FINRA registration and state licensing. Option D. Delegate the entire responsibility for verifying the new hire's qualifications to the Human Resources Department, trusting their standard onboarding procedures. The correct answer is B. Directly access and review the individual's FINRA registration status and any required California state licenses through official regulatory databases before allowing them to engage in any securities-related activities. Explanation. This scenario is professionally challenging because it requires a supervisor to balance the firm's need for efficient onboarding with the absolute regulatory imperative to ensure all associated persons meet the stringent qualification requirements before engaging in any securities activities. Failure to do so can lead to significant regulatory sanctions, reputational damage, and harm to clients. Careful judgment is required to navigate the nuances of regulatory compliance while maintaining operational effectiveness. The best approach involves proactively verifying the qualifications of newly hired associated persons by directly reviewing their FINRA registration records and any required state licenses before they are permitted to perform any regulated activities. This directly aligns with FINRA Rule 1210 and state securities laws in California, which mandate that individuals must be registered and qualified to engage in securities transactions. This proactive verification ensures that the firm is not allowing unregistered or unqualified individuals to operate, thereby preventing potential violations and protecting investors. It demonstrates a commitment to regulatory compliance and robust internal controls. An incorrect approach would be to rely solely on the applicant's self-attestation of their qualifications, or to assume that the background check process automatically confirms FINRA registration status. Self-attestation is not a substitute for official verification and can be inaccurate. Similarly, a general background check may not specifically confirm FINRA registration or state licensing, which are distinct regulatory requirements. This approach risks allowing unqualified individuals to act in a registered capacity, violating FINRA Rule 1210 and California state regulations. Another incorrect approach would be to permit the new hire to begin performing administrative tasks related to securities sales while awaiting registration approval, with the understanding that they will only engage in client-facing activities once registered. While seemingly a minor deviation, even administrative tasks closely tied to sales activities can be construed as engaging in the securities business, which requires registration. This approach creates a gray area and increases the risk of inadvertent violations of registration requirements under FINRA Rule 1210 and California law. Finally, an incorrect approach would be to delegate the entire responsibility of verifying qualifications to the Human Resources Department, without direct oversight or confirmation from the registered principal responsible for supervision. While HR plays a role in initial hiring, the ultimate responsibility for ensuring that associated persons are properly registered and qualified to perform their duties rests with the firm's registered principals. Relying solely on HR without a direct verification step by the supervisory principal fails to meet the supervisory obligations outlined in FINRA Rule 3110 and state regulations. Professionals should adopt a systematic process for onboarding new associated persons. This process should include a clear checklist that mandates direct verification of FINRA registration status through FINRA broker check or similar official channels, confirmation of any required state licenses, and review of any other applicable qualification, requirements prior to the individual commencing any activities that require such qualification. This proactive and documented approach ensures compliance and mitigates risk. Question 20. Risk assessment procedures indicate that a registered representative in New York is considering providing a personal loan to an employee of a different municipal securities firm located in New Jersey. The registered representative is unsure if this transaction requires any specific notification or approval from their employing firm. Under FINRA regulations, what is the most appropriate course of action for the registered representative to take before proceeding with the loan? Option A. Execute the personal loan and then notify the employing firm's compliance department of the transaction within 30 days. Option B. Inform the employing firm's compliance department verbally about the intended personal loan before proceeding. Option C. Obtain prior written approval from their employing firm's compliance department before engaging in the loan transaction. Option D. Proceed with the personal loan, as it is a private financial matter and does not directly involve the purchase or sale of securities. The correct answer is C. Obtain prior written approval from their employing firm's compliance department before engaging in the loan transaction. Explanation. Scenario analysis. This scenario presents a professional challenge because it involves a registered representative's personal financial dealings with an employee of another municipal securities firm, which can create conflicts of interest, potential for insider trading, or the appearance of impropriety. The FINRA rules governing such transactions are designed to maintain market integrity and protect investors by ensuring fair dealing and preventing the misuse of material non-public information. Careful judgment is required to navigate these rules while respecting personal financial relationships. Correct approach analysis. The best professional practice involves obtaining prior written approval from the employing firm's compliance department before engaging in any transaction with an employee of another municipal securities firm. This approach is correct because it directly aligns with FINRA Rule 3050-D, which mandates that a registered person must obtain written consent from their member firm prior to engaging in any transaction in securities with or for the account of an employee of another member firm. This proactive disclosure and approval process allows the employing firm to assess potential conflicts of interest, ensure compliance with regulations, and maintain proper supervision, thereby safeguarding both the firm and the integrity of the municipal securities market. Incorrect approaches analysis. Engaging in the transaction without any notification to the employing firm is professionally unacceptable because it violates FINRA Rule 3050-D by failing to obtain the required prior written consent. This bypasses the firm's supervisory responsibilities and creates a significant risk of regulatory noncompliance and potential conflicts of interest. Seeking verbal approval from the employing firm's compliance department before executing the transaction is professionally unacceptable. While it shows some intent to comply, FINRA Rule 3050-D specifically requires written consent. Verbal approval lacks the necessary documentation for audit trails and regulatory review, leaving the firm vulnerable to compliance issues and failing to meet the explicit requirements of the rule. Assuming that because the transaction is a personal loan and not a direct securities purchase, it falls outside the scope of FINRA Rule 3050-D, is professionally unacceptable. The rule broadly covers any transaction in securities, and while a loan might not be a direct purchase, it can still involve the transfer of funds that could be used for securities transactions or create financial entanglements that lead to conflicts of interest or the appearance of impropriety, especially when dealing with an employee of another municipal securities firm. The spirit of the rule is to prevent undue influence and ensure transparency in dealings between individuals associated with different firms in the municipal securities industry. Professional reasoning. Professionals should adopt a proactive and transparent approach when dealing with situations that could potentially involve conflicts of interest or regulatory scrutiny. The decision-making framework should prioritize adherence to specific FINRA rules, particularly those concerning interfirm dealings and employee conduct. When in doubt about the applicability of a rule, the safest and most compliant course of action is to seek explicit written guidance and approval from the firm's compliance department. This ensures that all actions are documented, reviewed, and aligned with regulatory expectations, thereby mitigating risk and upholding professional integrity.